Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask me any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your questions are, as long as they are legal questions, please feel free to call on the number that appears at the bottom of the screen. A couple of minor points before we get going. Obviously, on a live show, it's not possible to take very detailed information from viewers who call in. If it transpires that I need to speak to you in depth and there's a lot of information that I need to take from you, then I'll ask you to leave your number with the control room and then I will have a more thorough discussion with you off air. Likewise, if it transpires that I need to look at your documents before I can advise you further, sometimes that does happen. For example, where you're dealing with a matter where it's a matter that's gone to court, or it's an immigration matter where you've received a refusal letter, it's probably helpful if I look at the letter before I advise you properly. So if it's the case that I need to look at your documents, or as I said before, I need to have a more in-depth discussion with you, then I'll ask you to leave your number with the control room and then I will have that discussion with you off air. Now, this is the free legal advice show, so any advice that I have to give you after I've seen your documents, or I've had a more thorough discussion with you, will be part of the free legal advice show, and it will be absolutely free of charge. And the way you can get in touch with me is, as I said, on the landline number, which appears on the bottom of the screen. You can speak to me live by calling on the landline number. Or alternatively, another very popular way of getting in touch is to simply send me a message on the mobile number which appears at the bottom of the screen. I appreciate that sometimes legal matters are confidential. You don't necessarily want to come on air live and discuss your confidential, sensitive matters. And if you feel more comfortable, and if it's easier for you to get advice by sending a message in on WhatsApp or by text message, then that is obviously an easier way, and it's something that you're more comfortable with. That's absolutely fine. Please do send us a message on that mobile number, and that message will come through to me live on air, and I will be able to address your query whilst we are live on air. So you can give me a ring directly on the landline number, speak to me live on air, or as always, you can send your message through on the mobile number. Okay, so we've had a couple of questions coming in already. So let's look at some of the questions that have already come in on the mobile number, WhatsApp messages. But as always, please do feel free to pick up the phone and give me a ring. Now, first question that's come in relates to lockdown. And in particular, what our viewer is asking is as follows. As you're aware, some of the countries have been listed as red list countries. If someone has been granted a visa to come to the United Kingdom and they are travelling from a red list country, is it possible for them to travel to the United Kingdom, for example, in order to join their spouse who is in the United Kingdom and the visa has been granted on that basis? Interesting question. This is something that's been coming up quite regularly in practice. Now, obviously, the system for applying for visas, that's been in place for a while. That's certainly been up and running whilst we've had a lockdown here. So people who are abroad, applicants who are abroad, who are wanting to come to the United Kingdom, have been able to apply in their home country for a visa to come to the United Kingdom. That could be various different types of visas that they are applying for. For example, they could be coming on a spouse visa, which is, I think, what this particular question is aimed at. So you could have somebody who's traveling to the United Kingdom in order to meet their spouse, to live with their spouse on a permanent basis. Alternatively, there are a whole host of other visas that applicants might have applied for. They're now successful and they now want to travel to the United Kingdom based on the visa that's been granted. For example, they may be coming to work. They may be coming to the UK as a student. They may be coming to the UK in order to start a business. They might have some kind of business type visa. The basic position is this, and obviously somebody who is a British national is able to travel to the United Kingdom. Someone who has indefinite leave to remain is able to travel to the United Kingdom. There is then another category, the last category, which has been referred to by the government and the Home Office as covering those people who have residency rights in the United Kingdom. So they're people who have residency rights in the United Kingdom. Now the question really is, what does residency rights mean? Who falls into that category? Obviously, the first two categories are quite clear. Somebody who's British is allowed to travel to the United Kingdom from a red list country. Somebody who has indefinite leave to remain, permanent residence, has the right to travel to the United Kingdom from a red list country. But we have this category at the end where it's referred to by the government and the Home Office as someone who has residency rights. Now, the position appears to be this: anybody who has a longer term visa, so not somebody who has a visitor visa to come to the United Kingdom, someone who has a visa which is more long term, obviously it's not indefinite leave to remain, that falls into the second category. So a longer term visa, typically it's somebody who is coming to the United Kingdom in order to settle in the United Kingdom, such as a spouse, or it could be somebody who's coming on a more longer term basis, but not settlement, such as somebody who's coming as a student. Normally, those visas have a minimum duration of 1 year. Somebody who's coming to the United Kingdom in order to work. Their visas have, generally speaking, a minimum duration of 3 years, although they can be shorter. So these people who have some kind of right, although it's not the right to live in the UK permanently, but it's some kind of right to live in the UK for a longer term basis, longer than what a visitor visa duration is. They are entitled to travel to the United Kingdom. There's a lot of confusion around this, and travel agents aren't particularly certain as to who is or who isn't able to travel. We've had a number of applicants in practice who have actually travelled to the United Kingdom on a spouse visa, with a 2.5-year spouse visa, without any difficulty, because they fall within the last category, which is that they have residency rights in the United Kingdom, the right to live in the United Kingdom. Now, obviously, the problem with travelling from a country which is on the red list is that there is an absolute requirement that you will need to quarantine in a hotel. The exceptions to that are very, very limited. In practice, you have to work on the basis that you will need to quarantine at an approved hotel. There are extremely limited exceptions to that. Severe illness is one. I'm dealing with a similar matter at the moment. It's very difficult to come within the exemption. So if you do travel from a red list country, whether you're somebody who has a British passport, someone who has indefinite leave to remain, or somebody who's coming to live in the United Kingdom on a longer term basis, assume that you will have to stay at an approved hotel for at least 10 to 11 days before you are released. And even with the tests that are done, even if they come out negative, you will still have to stay at the hotel for 10 days. But I hope that answers your question. In a nutshell, in answer to your specific question, although you don't have a British passport, you don't have indefinite leave to remain, because you have residency rights, you can travel to the United Kingdom. But thank you very much for that question. Have a number of other questions coming in. We'll deal with that. But if you do want to speak to me live on air, you can call on the landline number, And as always, you can continue to send your messages in on WhatsApp. Let's look at the next question that's come in. Okay, and our viewer says, I'm a Spanish national. I would like to sponsor my parents and my wife and children to come to the United Kingdom. What are the main requirements? Will it be harder if I sponsor them after the 30th of June 2021? So a Spanish national wanting to sponsor parents, wife and children, and asking two questions really. What are the requirements, and will it be more difficult after 30th of June? Now, I'm assuming that the Spanish national, the person who sent the question in, is already in the United Kingdom and has been in the United Kingdom since at least before the 31st of December 2020. So if you, as the Spanish national, you've been in the UK before the 31st of December 2020, it is much easier for you to sponsor your parents, your wife and your children to come to the United Kingdom if you make the application before the 30th of June. It's going to be extremely difficult to sponsor your family members after the 30th of June 2021. Now, this is a complex matter, so what I will do is take you through what the current requirements are up to the 30th of June, and I'll demonstrate how easy it is to sponsor up to the 30th of June, and I will also deal with what the requirements are after the 30th of June and how difficult it is after the 30th of June. We're taking a short break. We'll come back and I'll look at this in greater detail after we come back. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. If you want to speak to me live on air, you can bring on the landline number that appears at the bottom of the screen. Alternatively, you can send me a message on the mobile number which appears at the bottom of the screen. That message will be sent through to me live on air and I'll be able to address your question or query. Okay, just before the break, we were looking at the question that came in from a viewer who is a Spanish national, and I assume he or she has been living in the UK for a while, but certainly prior to the 31st of December 2020. The question is what the requirements are to sponsor parents, to sponsor a spouse, and to sponsor children to come to the United Kingdom. Now, the question really is whether the requirements are going to be more onerous after the 30th of June. Now, before the 30th of June, it's extremely easy to sponsor close family members to come to the United Kingdom, whether it's parents, spouse, or children. The requirements are incredibly easy to satisfy. So, for example, if you're sponsoring parents to come to the United Kingdom, you would be demonstrating that you have registered yourself under the EU settlement scheme. Straightforward. Most people, most European nationals that I know have come across have now already registered themselves under the EU settlement scheme. So they, once they're registered under the EU settlement scheme, all you're really showing is your relationship to your parents. So all you're demonstrating is that they are your parents. It's a very simple way of doing that. You simply submit your birth certificate, and your birth certificate has your parents' details on it. That, along with a copy of their passport, is submitted. From here, you'll submit a copy of your passport and your settlement number. In reality, that's all you need to do. Parents who are coming over to the UK, any other close family member who's coming to the UK, doesn't even need to apply for a TB certificate or an English certificate. So the requirements are very, very simple. You're simply demonstrating that you are the parents of the European national who is in the United Kingdom and has pre-settled or settled status under the EU settlement scheme. For your spouse, the main document is going to be the marriage certificate. Again, you're having to demonstrate that the marriage took place prior to 31st of December. You've got your marriage certificate, you've got photographs, etc. together, marriage photographs, normal photographs. Essentially, that is the requirement. Again, there's no TB test, there's no English test, there's no financial requirement that needs to be met. You don't have to show that there's sufficient accommodation for your wife. And for your children, you're demonstrating that they're your children. And for that, again, the main document is the birth certificate of the children, which should have you as the European national, your name on the birth certificate. So it's really as simple as that. The key thing here is this, that prior to the 30th of June, there is no financial requirement, there is no accommodation requirement, there is no English language requirement, there is no TB test requirement. So it's much easier to make this application prior to the 30th of June 2021. What happens after 30th of June 2021? The big difference is one of those categories, parents, spouses and children, one of those categories falls out of the scheme completely. So it will be extremely difficult, if not impossible, to sponsor parents to come to the United Kingdom on a permanent basis. That's going to be the biggest change. So however much you're earning, whatever your situation is in terms of savings and accommodation, it will be extremely difficult, if not impossible, to sponsor your parents. However, you will be able to sponsor your spouse and your children, but there will be a income requirement, accommodation requirement, English requirement, TB test requirement to be fulfilled. I'll look at this in greater detail after I've taken the next call. Hello, Assalamu alaikum. Hello.
Hello, Assalamu alaikum.
Ji wa alaikum salam. Thank you for calling. What's your question?
Brother, my question is, I'm detained in the UK, what I call in the journal, or what I call in Brook House.
Okay.
And I've been in UK 20 years. I have 4 children.
Okay.
And then I've been detained in the detention center for 1 year.
Okay.
And they tried to deport me to Somalia and separate me from my children.
Okay. Okay. Now, why are they trying to deport you from the United Kingdom? What's the reason that they've given you?
The reason they give me is they're telling me because I used to have indefinite leave to remain in UK and they revoked it. And that's the reason now they want to deport me. And I have 4 children born in UK, aged 10 and...
I understand. Why did they revoke your indefinite leave to remain?
Because I commit a felony.
Okay, all right. And in terms of the length of your prison sentence, how long was it?
10-week sentence, brother.
How long, sorry?
I was given 20 weeks to do 10-week sentence.
Okay, all right. Now, so what would normally happen is when that happens, they normally let you appeal against the decision. Have you gone through the right? Have you been given a right of appeal?
They're telling me all my case is exhausted.
Okay.
But I want to fight because of my children. I don't want to abandon my children. Age 10, 8, 6, and 2 years old.
Okay. So has the Home Office made a deportation order against you?
Yes.
Okay. When was the deportation order made? Just roughly a couple of years ago, 1 year ago? What was it?
No, just recently, about, let's say, last 6 months. 6
months ago. You know, when they made the deportation order, did they give you a right of appeal? Did you go to a tribunal?
Yes, my tribunal, they refused me again.
Okay. When did you go before the tribunal?
I think sometime it was like the 12th of April this year.
Okay, so you just recently gone to the tribunal. And
yeah.
So you've recently received a decision from the tribunal basically rejecting your appeal against the deportation order. Now, you would have been given the right of appeal against that to the upper tribunal. Have you been through that process?
At the moment, I have nobody to help me with a solicitor. That's why luckily I just come through this channel and I saw the advice you were giving. I was happy about it, and I thought maybe you could help me advice.
Okay, so in terms of the appeal before the tribunal, were you represented before the tribunal by lawyers?
No.
So why didn't you get representation before the tribunal?
Because I couldn't afford, and they give me legal aid, and the legal aid told me he could not help me.
Right, because you would normally be eligible for legal aid. On a deportation appeal, you would normally be eligible for legal aid. So, okay, all right. When did you get your decision from the tribunal? When did you get the refusal letter from the tribunal?
I got it early this month.
Okay, you would normally be given 14 days to appeal against that. Have you submitted an appeal at all?
I think my old solicitor, which was representing me, he submitted, but he told me he cannot go any further than that.
Okay, so recently, in terms of the appeal against the most recent decision that you would have got in April, you have submitted an appeal against the tribunal decision. You have you?
Yes, sir. Yes.
Okay, all right, okay. So you've taken the next step, which needs to be taken. Okay, the deportation order has been made against you. You've been to the tribunal, it's been refused. You have a further right of appeal, and your solicitor has submitted that. I think, look, if you've submitted, your solicitor has already submitted the appeal. Obviously, you need to wait for the outcome of the appeal. Did your solicitor make an application for bail on your behalf?
Well, yes, bro. They've given me 7 times. They give me bail on principle.
Okay.
And what happened when I went to the court on the 12th of April, they told me forget about this 7 times you have bail on principle, because what happened is I was waiting for accommodation. I give them 5 different addresses. They refused it, and they told me we're going to apply something called Section 4.
Okay. So your bail application, your bail applications have been refused, have they?
No, at the moment, as I'm speaking to you, I have bail on principle.
Okay, in principle, you've got bail, okay?
Yeah.
Okay. But were you not able to find any accommodation?
I give them 5 different addresses. They refused. They tell me it's not suitable.
Why was it not suitable?
I don't know, because the probation saying it's not suitable, this address.
Okay.
But now, at the moment, let's say from the 7th of June, I have no probation. I have nothing, because it's me and the Home Office. Because now it's a probation between us. I've been detained for 1 year.
Okay.
You know what I mean? And they give me a ticket last Monday. They bring me back from the airport.
Okay. Well, they're not...
I just, you know what I mean? I have children in this country. That's the only thing I have in my life left. 4 children born in the UK.
Okay.
I'm trying to stay with them, please.
No, I understand what's happened. The only difficulty is that your appeal against the deportation order has been unsuccessful. So you're unfortunately in some difficulty now. I mean, I don't know what happened at the hearing. I mean, I don't know whether your ex-partner or your children were able to give evidence. I don't know how old they are.
Yes, they do have all my wife is supporting me. They've got all my work on my children's birth certificate. You know what I mean? I've been here in this country 20 years.
Okay, all right, okay. It's a long period of time.
Yeah.
And I take it that if they revoked your indefinite leave to remain, you never had British nationality, I take it?
No, that's correct. I had indefinite leave to remain in the UK. They revoked it. I tried to put new asylum. They refused it. So I don't know what to do at the moment. I'm just confused. You know.
Okay, all right. I mean, it's a complex matter. The only difficulty I see is that in terms of what you can do, you've already done it. You've appealed against the decision. You're appealing against.
I've got mental issue Rule 35. I've done a medical report from the medical justice.
I suspect you've claimed asylum as well. What I can suggest is if you leave your number with the control room, then this is quite a complex matter. I can certainly have a discussion with you off air. If you leave your number with the control room, I will try and call you back to look at options. My only concern is it seems like your options which are available to you, you've exhausted most of them in terms of appealing against the deportation order, appealing against the refusal of the tribunal to overturn the deportation order. you probably exhausted any appeal rights against the asylum refusal as well. So the problem I see is our options might be limited, but I'm more than happy to look at this with you if you leave your number with the control room. It's a complex matter. We're taking a short break. We should be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. To speak to me live on air with any questions that you have, any legal questions that you have, please call on the landline number that appears at the bottom of the screen. Alternatively, you can send me a WhatsApp message which will be sent through to me live here in the studio, and I can address your question live on air that you send through on WhatsApp. Now, just before the break, we had a very complex matter relating to a person from Somalia who has unfortunately has had a deportation order made against him, and we looked at what the options are appealing against that complex matter. I've asked the caller to leave their number with the control room, and then I'll have a discussion with them later on in terms of options. Okay, we've had a number of questions coming in on WhatsApp. We've got a message that's been sent in, I think, last week and this week as well, relating to selling goods, services in the marketplace. And the question that's been put is whether it's legal to sell certain goods and services in the marketplace. So let's look at that. I mean, our viewer is quite persistent. I think we get this question quite regularly. So let me deal with that head on. In terms of things that you want to sell, whether it's on Amazon, eBay, wherever it is, obviously with certain products, certain goods and services, there are laws associated with that. With other things, you're quite free to sell them. So for example, if you're selling an old pair of shoes or something, fine, you get a lot of people selling designer goods. As long as they're legal, it's okay to sell. There are other things that if you want to sell are regulated. So it just really depends on what kind of goods and services you want to offer, whether it's a category which falls within the regulated category or whether it's completely unregulated. And there's obviously certain things, certainly there are things that you can't sell online, and those things, it's quite obvious to most people. So our viewer who's quite persistent, who keeps on asking a question about what you can sell, look at what you want to sell. Is it something that's regulated, not regulated? Do you think it's permitted, not permitted? Hope that answers your question. I know you're quite persistent and you've sent your question in regularly. But if you're not sure, as always, like you've done before, do send your question in again and I will give you a more thorough answer, maybe on air, maybe off air. But thank you very much for that. Now, just before that question, I was looking at the question about somebody who's an European national who's looking at sponsoring family members to come to the UK. And they're really looking at how the law changes on the 30th of June. European national who wants to sponsor their family members to come to the UK. 30th of June really is the cutoff date. After the 30th of June, it's going to be difficult. In terms of parents, you're not going to be able to sponsor your parents. So if you're going to sponsor your parents as a European national, you must do it before the 30th of June. In terms of wife and children, it is possible to sponsor them after the 30th of June. However, there's going to be the financial requirement that you're going to have to meet. You're going to have to be earning a certain amount of money. You will need to show that you've got adequate accommodation. You will need to show that your partner has passed the English test and the TB test. So if you're a European national and you want to sponsor your family members to come to the United Kingdom, really, you've got a month left. You need to get a move on and get the application in prior to the 30th of June. It's going to be extremely difficult to do it after the 30th of June. Hope that answers that question. Had a number of other questions coming in. Let's look at that. A long question regarding bankruptcy and immigration visas, etc. Let me just read the question out because I've not looked at the question. I'm just literally looking at the question as I'm talking to you live on air. Our viewer says, my question is this. I am on the verge of bankruptcy. Sorry to hear that. As I used credit cards to fund my small business, which has failed. I have limited leave to remain in the United Kingdom, and I will have to apply for an extension in July 2021. Will my bankruptcy affect my extension application? Now, I'm sorry to hear about the problems that you've encountered with your business. Unfortunately, a lot of people are in this situation. We've had the country in lockdown over the last year, which has affected a lot of small businesses. Now, some businesses have done well, online businesses, but a lot of other businesses, such as in the retail sector, where they haven't been operating online, they have struggled. So completely understand the situation that you're in, completely understand your predicament. In answer to your question, there is some good news, hopefully I can give, which is that there should be no impact. Your bankruptcy, or you being on the verge of bankruptcy, should have no impact whatsoever on your extension application. So don't worry about that. And I appreciate you've probably had a lot on your plate and you're concerned about what's going to happen in July. So look, if you do need to go bankrupt, and that's the only option, and the advice that you're given is that your best interests are served by going bankrupt, don't worry about the implications on your visa status. Don't worry about the implications on any visa extension applications. You will get your visa extended. The bankruptcy won't affect that. And obviously, in time, if you comply with the requirements of the trustee in bankruptcy, they will ask you questions about your financial circumstances. They may want to look at your documents, etc. If you're open and honest with them, then the trustee in bankruptcy will discharge you within a year. That's the norm. You're open and honest. You give them what they ask. They will discharge you within a year. Now, that being the case, when you get to the indefinite leave to remain stage, or later on when you apply for nationality, if you're a discharged bankrupt, if you've been discharged, then the fact that you were previously made bankrupt shouldn't, hopefully, adversely affect any nationality applications. But obviously, that's much later on down the line. Here, we're talking about a visa extension. Now, I don't know what the visa extension relates to. It could be relating to a spouse application that needs to be extended. It could be a business visa. It could be a student visa. But whatever it is, I can assure you on this, that as far as visa extension applications are concerned, there shouldn't be a problem with getting your visa extended. The bankruptcy, potential bankruptcy, won't affect your visa extension application. So I sympathize with the position that you're in, but one piece of good news is that immigration visa status is something that you don't need to be worried about. Okay. A number of other questions coming in. Let's look at that. But as always, if you want to speak to me live on air, you can ring on the landline number. Another question that's come in, the question is this, that I've received a Spanish passport last month. So sorry, the question's been sent in Urdu. I'm trying to work out what it says in English, but essentially what the brother is saying is that the Spanish nationality has just been granted. So what I am assuming is that the person who's been granted Spanish nationality is not in the country at the moment, and they want to come to the United Kingdom, and they want to apply for pre-settled status under the EU settlement scheme. The problem is this, that if you are a European national and you want to come to the United Kingdom to ultimately settle in the United Kingdom. No, you want to come to the United Kingdom like European nationals were able to do so before. The requirement is that you must have been in the UK at some stage prior to the 31st of December 2020. So the difficulty is anybody who gets European nationality now, like this viewer, or anybody who has held European nationality for a while but hasn't come to the UK prior to the 31st of December 2020, they unfortunately are no longer able to come to the United Kingdom under the EU settlement scheme to settle in the United Kingdom. They've really missed the boat, unfortunately. So if you get your nationality now, European nationality now, and you're abroad, if you already have European nationality, but you haven't been in the United Kingdom prior to the 31st of December 2020, you can't now come to the UK, unfortunately, to settle in the United Kingdom. You can come as a visitor. You don't need a visa as such. You simply present yourself at the airport and you're given 90 days to enter the United Kingdom at the airport. It is a visit visa. It does not lead to settlement, unfortunately. Now, if you think about it, this was the point behind Brexit, that free movement of people essentially would come to an end. And we've had this coming in for a while. And the cutoff date really was the 31st of December 2020, when the free movement of people came to an end. Now, the EU settlement scheme is there to deal with some matters such as dealing with people who are already here, who want to call their family members. They've been given a bit more time, but that grace period comes to an end on the 30th of June. But that's only for people who are here already by the 31st of December. They've been given up until the 30th of June to call their family members. After the 30th of June, it really does come to an end. But going back to your question, as a European national, if you haven't been living in the United Kingdom prior to the 31st of December, you can't now come as a European national to settle in the United Kingdom like people were able to do before. That has now come to an end, and a European national now is in the same situation as any third country national. It could be somebody from India, Pakistan, Bangladesh, Middle East, whatever it is, UAE. The rights that a European national now has is identical to that. We'll be taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. To speak to me live on air with any legal questions that you have, please call on the landline number that appears at the bottom of the screen. Alternatively, you can send me a message on the mobile number that's at the bottom of the screen. The message that you send on your mobile number will be sent through to me live here in the studio, and I will be able to answer your question. Okay, a couple more questions that have come in on our WhatsApp number there. Let me read the question out and let's look at what the position is. Okay, the next question is this. In 2011, I did my life in the UK test. My English is brilliant. Okay. I was granted indefinite leave to remain in 2017. I am applying for British citizenship now. Do I need the B1 English test, or will my life in the UK test be sufficient? I used my life in the UK test when I applied for indefinite leave to remain. Okay, so applied for indefinite leave to remain in 2017. What I'm not sure about looking at that question is this, that if you applied for indefinite leave to remain in 2017, so indefinite leave to remain in 2017, most visa categories under which you apply for indefinite leave to remain, most visa categories have an English language requirement, which is fulfilled by showing that you've passed the Life in the UK test, like you have, and also by showing that you've done the B1 test in English. So my understanding is that you probably have done not only the Life in the UK test, which you say you've done, you've also done the B1 test in English. Now, if it's the case that in 2017, when you applied for indefinite leave to remain, the category that you applied under, for example, spouse applications, which lead to indefinite leave to remain, long residence applications, which lead to indefinite leave to remain, work-based applications, which lead to indefinite leave to remain, if it's one of those categories, 90% of the categories which have an English language requirement, and you demonstrated that you passed the Life in the UK test and you passed the B1 test in English, you don't need any new certificates now. You can simply rely on the Life in the UK test that you did before and you used successfully. And you can use the B1 test that you relied on before and successfully relied on previously. You can rely on those both certificates and those two certificates for your indefinite leave to remain application and your nationality application. Now, on that, what I should say is that obviously there are some categories where there is no English language requirement at all. For example, if you got indefinite leave to remain based on being a victim of domestic violence, or you got indefinite leave to remain based on the bereavement of your British partner. So there are some very limited, very, very limited categories. Or you got indefinite leave to remain because you had a 3-year discretionary leave, which was extended once more. So you completed 6 years under the old discretionary leave scheme. So if you fell within one of those very limited schemes and you applied for indefinite leave to remain where there was no English language requirement at that time, then you do need the Life in the UK test and you do need the B1 test in English. So in practice, in my experience, domestic violence-based indefinite leave to remain applications didn't require any English qualifications. Where the partner who's British has passed away and the indefinite application is based on that, doesn't have an English language requirement, or under the old discretionary leave scheme where you completed 6 years, 3 + 3 years, that didn't have an English language requirement. So if you got your indefinite leave under one of those categories, then you do need to do the B1 test and you'll show your Life in the UK test as well. If, however, you are like the vast majority of applicants that you see in practice, you did satisfy the English language requirement, you were required to, and you did satisfy the English language requirement in 2017, then you don't need to do any new tests now. You can simply rely on your old certificates that you used in 2017. Hope that answers your question. If I've missed anything, please do send me a follow-up question on WhatsApp, or by all means, please do give me a ring on that landline number. Okay, let's look at the next question that's come in. It's quite a long question and it does look like something's gone wrong here. Let's see what the best way of putting this right is. So the question is this. I'll read the question out. I am currently on a spouse visa in the United Kingdom, which is due to be extended. I asked a women's refuge for help with temporary accommodation as I couldn't stay at my partner's house. However, they, as in the women's refuge, have misrepresented me and notified the Home Office that I am destitute, and they have also applied for a DDV concession without my consent. What do I do? I am still in a relationship with my UK sponsor. So our viewer is in the United Kingdom on a spouse visa. It sounds like they are here during the first 2.5 years. They will be applying for an extension of that spouse visa in due course. But something's gone wrong before that. Our viewer has sought the help of a women's refuge. They've maybe misunderstood or misrepresented what the situation is to the Home Office, and they have applied for a DDV concession, which is essentially, they've said to the Home Office that my partner they've essentially said, my partner and I have split up now, and essentially said that you're the victim of domestic violence, and the DDV concession allows you to access public funds for the next 3 months, gives you the opportunity to get your application in order and to apply for settlement on the basis of being a domestic violence victim. Now, you say that the Women's Refuge have got this all wrong. What you need to do is this. First step is you do need to get in touch with the domestic violence concession unit within the Home Office. So if they have applied for the concession already, I suspect you have already received, or you are already about to receive, confirmation from them that you've been granted a 3-month visa and you're eligible to access public funds. So I suspect that's happened or is about to happen. So your visa status is about to change, if it hasn't changed already, from your normal spouse visa to this 3-month visa, which allows you access to benefits for 3 months and which gives you time to apply for settlement on the basis of being a victim of domestic violence. Now, if that's happened, you need to get in touch with the domestic violence unit within the Home Office. You need to explain to them what's happened, that a mistake has been made. If possible, the Women's Refuge need to do a letter explaining that they misunderstood what had happened, and in error they applied for on the basis that you were a victim of domestic violence and you needed to be eligible for public funds. It's a mistake that they've made. You need to get in touch with the Home Office on that email address that you normally submit domestic violence applications to. You need to tell them what's happened in order to try and put this right. Now, hopefully, what the Home Office will do is cancel the 3-month visa that they have now given you and reinstate your normal spouse visa that you had before. And I hope that's what's happened. The Home Office is entitled to do that. Let's hope that they agree with your request, that you were never claiming that you were a victim of domestic violence. You never wanted to apply for public funds. You never wanted that 3-month visa card that they give you to access public funds. Hopefully they'll accept your argument and they will reinstate the old spouse visa. Now, if they don't, what you need to be careful about is that card that you've got, which normally expires within 3 months. If you're together with your partner, you need to apply for your spouse extension within the expiry date or before the expiry date. So if they've granted you a new card now in the end of May, that card will come to an end in around the last week of August. So you get 3 months. If they don't agree to reinstate your old spouse visa, in these 3 months, you need to change your visa again, back from those 3 months, back into the spouse visa. So you need to demonstrate that, you're living together, the income requirements have been met, the English requirement has been met. So if your old spouse visa is not reinstated, you need to get your spouse extension application in before then. Hope that answers your question. We've had a number of other questions coming in, but unfortunately, we are running out of time. I'll try and address this last question very quickly. question is, I've been in the UK for 12 years, put an application in 2016, refused, appeal exhausted, further submissions submitted. In July 2020, now I'm still waiting for a decision. So our view has been in the United Kingdom for 12 years. Previous visa application was refused. Further submissions have been submitted. What do you now do? Well, the reality is, if you've submitted further submissions, you're going to have to wait for a decision. It is taking a long time for further submissions to be decided. I don't think, unless your circumstances are very good, I don't think you should look at submitting a new application at this stage. Wait for a decision on your further submissions. Wait and see whether you're granted a right of appeal or not. Now, unfortunately, we are running out of time. I will deal with this in greater detail when we come back next week. By all means, if you want to have a more thorough discussion with me in relation to this, you can call me next week. That brings us to the end of the show. We'll be back, inshallah, next week on Tuesday at 8 o'clock. Until then, Assalamu alaikum.